Good afternoon. Welcome to our webinar, Practical Considerations in Preparing for the Financing or Sale of Your Business, presented by the Florida SBDC at UCF. Hello, my name is Jairo Batista. I'm a consultant here with the organization. For those who are new to the SBDC, we're an organization that helps businesses grow and succeed. And we do that in a few ways. First, we provide no-cost consulting. You can come and speak with a consultant as many times as you like. Our consultants have expertise in a wide variety of areas, including sales, operations, human resources, financing, accounting, and much more. We also provide market research at no cost. So if you have some important business decisions, please come see us first. We can probably provide you some data that can help you make the best decision for your business. We also provide webinars and seminars like these, and different training opportunities. And lastly, we provide second stage programs for second stage businesses who are looking to take the next step forward. We just released a new program called the Business Recovery Teams Program, where we help small businesses who are impacted by the COVID-19 pandemic kind of survive it, and also help them put in a position to thrive after the pandemic. For more information about that program, you can visit our website at www.sbdcorlando.com. Again, it's a free service that you can utilize for your company. Just a few quick housekeeping tips. Everyone is muted right now, so if you have any questions, please feel free to drop it in the chat. We'll ask the questions to the presenter as we go along, so don't be shy, and feel free to use that. This webinar will be recorded and be uploaded on YouTube in the near future. So if you miss something or you have to leave early, we'll provide you a YouTube link in a few days. Without further ado, I'm going to introduce you to our speaker. His name is Terry Brennan from Brennan Legal Group, and he's also counsel for Bailey & Duquette. Terry Brennan is a corporate intellectual property and technology transaction attorney whose practice focuses on representing investors, technology and manufacturing companies, financial institutions, and healthcare providers in transactions directed to the commercialization of innovation and the reward capital risk. And Terry offers practical, cost-effective, and creative assistance to emerging and established clients in angel and venture financings, mergers, asset and stock acquisitions, divestitures, reorganizations, and roll-ups, and provides specialized counsel to healthcare institutions and related service providers in a variety of SaaS or software as a service, master services, technology licensing, information processing, and privacy-focused transactions. Prior to establishing the Brennan Legal Group and joining Bailey Duquette as counsel, Terry was a partner at Holland & Knight and Russell & Andres. In these positions, Terry has had substantial experience in representing technology, manufacturing, health information systems, online marketplaces, and entertainment clients as outside corporate intellectual property and technology transactions counsel. Terry also has been the vice president and general counsel of IBEX Healthcare Systems, a health information systems joint venture between IBM and Baxter Healthcare Corporation. At IBEX, Terry was responsible for supervising all corporate contractual, technology licensing, mergers and acquisitions, and general commercial matters affecting what was the second largest health information systems company in the United States. Terry is a native New Yorker and graduated from the Georgetown University Law Center, where he served as the editor of the Georgetown Law Journal. For many years, he practiced with two prominent Wall Street firms and participated in several of New York's emerging technology support organizations. Terry is currently active in advising a number of small business development to veterans and theatrical and charitable groups. So you're in good hands today in today's webinar. So without further ado, I'd like to turn it over to Terry Brennan.
Thank you. Thanks very much for everybody attending. I don't know why anyone would want to listen further to me with that sort of blowhard introduction, but hopefully the rest of it will be more fun and informative. In short, I am a business, corporate, and technology transactions lawyer, and I've been practicing for many years and have engaged in pretty much every type of securities, mergers, technology transaction that you can think of, none of which we are really going to talk about today. In the course of negotiating and closing probably several hundred acquisitions and financing transactions, particularly with technology companies, one of the things that has occurred to me, particularly on those occasions where a deal does not proceed to a closing, is how ill-prepared many clients, in the case where I'm representing the business seeking financing, or in the case where I'm representing a investor, how ill-prepared so many clients are for both the financing and the mergers and acquisitions process. So what I want to try to do today are talk about the types of simple housekeeping measures that a company that is intending to obtain financing or contemplating a sale should take prior to the time that the transaction gets underway, and as well as during the course of the transaction, to introduce you to some of the fundamental tools of financing and mergers and acquisition transactions, and to provide you intermittently with some examples of the types of things not to do. I've, in the course of representing many clients, and even very recently in a merger in which I am still trying to close because of problems that occurred, I have found that recent merger transaction to be an excellent a teaching example, if you will, because there were so many mistakes made by my client, who was the merging client, that is the company that doesn't survive the merger, and so many on the other side, that I thought it might be instructive to give some examples of that. Anyway, with that said, we're not going into to discuss the legal content of acquisition agreements or merger agreements or any of that. I'll be pleased to respond to questions if someone has a specific question on that, either during the course of the presentation or afterwards if you would like to contact me. But what we're going to try to do here is to concentrate on a $10,000 overview. So with that said, the first thing that you want to try to understand before your company goes to seek financing, that is before you meet with an investor, before you have a initial meeting to present an executive summary or provide information about your company, is to be able to clearly state why you are needing the financing. There are so many companies who are so involved with their internal needs that in the first meeting with an investor, they say things like, well, I want to repay the debt that the loans that I've extended to the company, or I haven't taken a salary in 2 years and I want to use the money to pay myself. Investors don't care about that. The investors want the funds that they're extending to the company to be used to assist in the capital growth of the company. That is software development, manufacturing processes, maybe the acquisition of additional inventory, the obtaining of a expensive license for a software system. But you want to avoid generalizations such as, we want to use it for marketing, we want to help the company grow. Make certain that you have thought out exactly what you're going to use that the funding that for which you are seeking, and how that use is going to help the company grow and therefore provide a return on the investment that the investor is making in the company. You'll also want to pay attention to some basic corporate housekeeping measures, as we call it. That is, For example, you would be surprised how many emerging companies think they have shareholders or members in the case of an LLC, when in fact they have never actually formally issued stock, nor have they formally issued membership units, which is the equivalent of stock in a limited liability company. There's few things that are more embarrassing to a company's credibility in the course of a financing transaction than to find out that the founding shareholders are not in fact shareholders, because there's no corporate record, no resolutions, no properly maintained stock ledger that shows that they're shareholders, and a lot of times that can end the transaction right there. So you'll want to observe customary corporate and LLC organizational preparation, and that means a lot more than simply filing the articles of incorporation or the articles of organization. Many companies think that's all they have to do. It is not. There are various types of organizational documents that investors are going to want to see having been executed when or shortly after the time they meet with you. Almost any competent lawyer can advise you of those, and I'm certain that the SBDC can give you more details on that, but just as a quick overview, in the case, for example, of a corporation, those are the shareholder agreement, the bylaws, the shareholders resolutions, appointing the directors, confidentiality agreements, stock certificates in some cases, or at the minimum, a stock subscription agreement. Those types of documents, there's usually 5 to 7 of them, depending upon the nature of the business of the company. Make certain that you've taken the time to do that. The other thing that's equally important, particularly for those technology companies that are participating in this call, is that if you are using outside developers or contractors to develop software, make certain that you have consulting or independent contractor agreements with them in which they assign their rights to the software that they're making. Why is this important? Because under the Copyright Act, if an independent contractor is developing software for your company, and even assuming that you are paying them a great deal of money to do that, they own, presumptively, they own the right to the copyright, which means they own the software. Your company will have a license, a limited license to use it, but they won't have the right to transfer the software. And if they don't have the right to transfer the software, if the company doesn't, you're not going to get investment. There's nothing that will close down a financing negotiation as quickly as the investors discovering that the company doesn't own the assets, particularly the software assets in which it is investing. I'm going not to address much that's on the next couple of slides, except to encourage you to read them. And the reason I've included them is in this changing COVID environment, the issue of the extent to which a company has complied with relevant COVID regulations prior to a financing becomes a subject of discussion with regard to what is technically called indemnification obligations. I'm not going to go into the indemnification in any detail in this discussion, but fundamentally what it means is that the company will pay the investor or the acquiring party for the legal fees and any damages that the acquiring party or investor incurs as a result of the company's not complying with the law prior to the closing, or the company's making a representation during the negotiation and that representation turns out to be false. So the when I first gave this presentation, or a similar presentation about 6 months ago, this list of COVID regulations was about 3 times as long. And because every jurisdiction, every locality was having various restrictions on what businesses could do, and many of the restrictions weren't consistent. You would have a city within a county, within a state, all having somewhat different regulations. Now, as things have, at least in Florida, as things have more or less evened out, there are fewer restrictions. But make certain that you take a look at that list, or that you contact the agencies that are linked in and on the PowerPoint, and be prepared to demonstrate that during these period of COVID shutdowns and restrictions that you have complied. Because again, the one thing that an investor and an acquirer wants is the lack of problems. They don't want to have to deal with problems that are not related to the business, and complaints and lawsuits by your employees or contractors or whatever, that the company didn't comply with COVID while they were on premises or working, creates a distraction in which investors are simply not interested. Okay, so talking about financing, let's talk about the players, typical players in a financing transaction. There are basically 2. Well, there are 3. The first are wealthy individuals, and that's more or less of a self-defining term. Your rich Uncle Harry, or someone who you have the good fortune to know and is a wealthy benefactor and feels the need to invest several $100,000s in your business. Those are you certainly want to be grateful for that type of investor. Oftentimes, however, the wealthy individual investor will make very non-customary demands on the company, such as demanding an exceptionally high percentage of equity for a relatively small amount of money, without any regard to the impact of that large amount of equity on the company's future attempts to raise financing. Sometimes they will insist on controlling the company in a way that is inappropriate for a minority shareholder, and other times they'll just become intrusive. So when you're dealing with an individual investor, it's very much a question of knowing them, evaluating their personality, maybe knowing something about their business, their business habits. Up the ladder from the individual investor are angel investors, and angel investors can come in a broad spectrum. They can range from a group of 2 or 3 Wall Street types or wealthy businessmen who band together to invest in a company that either is interested to them or is related to their respective businesses. They might simply be, again, a collection of wealthy individuals who like to pool their money on speculative investments and are prepared to lose the money. They just enjoy the challenge. That type of investor may not have expertise in your business. And so before you rush in to accept an angel investment, you want to look at the business experience of the investor, because unless they can add something significant to your business growth, either through introductions to other possible business alliances, introduction to other investors, perhaps introduction to a big customer, if they don't offer that type of extra value added, it may not be worth the 25% of the company you're having to give away for $300,000 or $400,000. By contrast, there are some very fine angel groups, and there are certainly a couple of those in the Central Florida area who are in the business of investing in companies, and these angel groups are more closely resemble venture capital funds, which we'll talk about in a minute. The institutional angels, as I'll call them, are in the business of investing. They typically consist of membership by invitation only for wealthy persons who are, under the terms of the angel fund, are required to commit a certain amount of money each year towards investments. They oftentimes bring very good connections, particularly to venture capital firms, but they don't insist on some of the more stringent and management control terms that we'll discuss in a minute when we get to venture capital investors. There are typically an angel's going to want a return on their money from in 3 to 5 years. Some will stick around for an additional term. Some angel groups will not do subsequent rounds of funding. So when you invest, when you're looking at an angel group, you may want to consider whether, in addition to the 500,000 or 800,000 or whatever that you're looking for now, whether you're going to need an additional round of investment down the line in 2 years. And if so, you may want to try to go to a venture group first if you are able to do that. Being selected, by the way, by an angel group or a venture group for investment is akin to winning the lottery, or maybe more closely to being selected out of the minor leagues to play Major League Baseball. The percentages of companies that are seen by angels, and particularly venture capital firms, and which are actually selected for financing, is probably less than 10%, and sometimes lower than that. This then raises the issue of how important it is for you to coordinate with groups like the SBDC in preparing your business plans and your executive summary. You're only going to get one shot. In whether that shot is emailing an executive summary of your business or the business plan itself, or actually meeting with a representative of an angel group or an investor group, a venture capital group rather, you're going to get one shot, and they are going to make the decision whether to proceed with you to the next stage based upon your presentation, your conduct, your personality at that initial meeting, and equally as importantly, on your business plan. So make certain that you spend the time getting the professional advice that you need before you proceed to any of these types of meetings. VCs, venture capitalists, are in business of making money from risk capital. They are typically what we call a pooled investment vehicle, usually organized in the form of a limited partnership. And what that means is that affluent groups, affluent persons, banks, trusts, ERISA plans, charities invest their money with the venture capital group, so that the VC group will then invest in reasonably reliable, high return capital risk assets. Typically, the venture firm is comprised of persons who have had substantial experience on Wall Street or Wall Street related investment banking, financial industry. Many times there are specialists within the firm. So for example, I've worked with venture capitalists who specialize in health information systems, others that specialize in the life science or some portion of the life science, others in drug development, some in electronic vehicles. That they basically have subject matter experts. And because of that fact, they are able to weed the wheat from the chaff very quickly in any discussion. Getting on the table, as the term goes, with a VC firm is very difficult. Typically, that's not going to happen as a result of sending them your business plan. You usually are going to have to be introduced to the VC firm by attorneys like myself and others who have experience in working with venture capitalists, or a broker who works with the firm. But usually a general mailing or a blind business plan sort of distribution isn't going to work. There's always exceptions, and I have represented some folks who have been fortunate enough to be one of those exceptions, but it certainly is by no means the rule. What's the advantage? VCs can really put a leg up to your company's growth. They will, because of their subject matter expertise, they will typically be able to introduce your company to sources of contractual arrangements, revenue, joint alliances. They may have political connections. They will be able to prepare your company for a second round of financing, usually in a what we call a syndicated arrangement, in which the first round venture capitalist allies with or teams with other venture capital firms to provide the company with subsequent rounds of financing. The rounds of financing, the initial round in a venture capital transaction is referred to as an A round, and subsequent rounds B, C, D, etc. Typically, by the time a company gets to a D round, they either have gone public or the VCs have decided that it's time for the company to sell its assets. But at any rate, a venture capital investment is a real asset to you in the company's growth. And again, repeating what I said earlier in the discussion, preparation for that, good housekeeping, being able to clearly articulate why you want the money and what you're going to do with it and what your vision is very important. So in that respect, what are they looking for? What do both VCs and angels look for? They're looking to invest in a company that has a protectable asset, protectable under the intellectual property laws, meaning, again, ideally something that is patentable, but if it's a software asset, at least something, a product, an application, a system, a solution that does not require a lot of third-party licenses for its fundamental functionality. They are looking for a niche in a large growing market. If you were, probably a good example is if you were the if you were the producer of a component of a lithium oxide battery 5 years ago, you would have been an ideal, your company would have been an ideal candidate for venture capital financing, particularly if you had a patent on the particular solution that you were offering. Similarly, on a less complicated level, if you were the manufacturer of masks or plexiglass partitions in the past 8 months, you probably would have been able to get successfully arranged for several rounds of angel financing, perhaps not venture capital financing, but certainly angel financing, because you had a market with a growing demand. If you had established by virtue of a trademark a well-known name in the market, then suppliers and restaurants and businesses like that would go to you to purchase. You'd be in a position to fulfill the orders, and it would be a product that people would pay for either repetitively or which it would purchase additionally as their businesses expanded. What the VCs also like to see is what we call barriers to entry. That is, that it's difficult for others to get into the business. And the best barrier of entry, of course, is patent, but an industry in which, for example, it takes a fair amount of prior capital investment in order to develop the business. That is one where there's a lot of manufacturing equipment required in order to produce a particular chemical. That type of thing is the area in which venture capitalists like to invest, because it's not going to be easy for some startup to come in and knock them off. So fundamentally, when you were meeting with an investor, you want to emphasize the unique nature of your product. You want to identify a market need. That is, why does the world need this new form of light bulb? You need to identify a market need which is going to involve a large volume of paying customers, or a segment of customers that will repeatedly purchase your product and will do that over a sustained period of time. All of this is fundamental to a venture capital or angel investment, because, as indicated previously, they're in the business of usually making high returns on their own investments, or making great multiple returns, usually 5 times the returns, on other people's money. So for that reason, don't make the mistake of thinking that a potential investor, no matter how affable they may be, shares your vision or your societal view or your political view of the value of your solution or your product as a uplifting contribution to mankind. They don't care about that. They care about making the money for the people who have entrusted them with their investments. And they would much rather invest in a gas-consuming vehicle that they know is going to be repeatedly purchased in the market by a large population than invest in a esoteric form of electric vehicle that a very small group of the population is going to purchase. There are exceptions, but fundamentally, they're in the business of making money for other people. Let's talk a bit about the types of agreements that are used in most financing transactions. In an angel transaction, there are fundamentally 2 forms of agreements that are most frequently used. A stock purchase agreement, or a membership interest purchase agreement, in which the investor directly advances money to the company in return for an issuance of equity. This is the least common way of investing for angel investors, because they usually prefer to use convertible notes. What's a convertible note? A convertible note is a loan to the company in the form of a promissory note that allows the angel investor to convert that note into the stock of the company by forgiving all or a portion of the principal amount of the loan that is owed by the company. More simply stated, using an easy example, if an investor extends a convertible note to the company of $1,000, it has the right to forgive that $1,000, or depending on the transaction, a portion of it, and in return receive stock in the company at a discount. Typically, a 20% discount. So basically, they are waiving the right to receive repayment in return for issuance of stock. The second type of agreement that we see in angel groups, not very often with venture capital groups, is something called a simple agreement for future equity, or SAFE agreement. A SAFE agreement is a wonderful agreement if you can obtain it, because basically what it involves is a situation in which the investor has extended funds to the company. It is not a loan. In its most pure form, it's the investor cannot call the money, cannot demand the repayment of the money, and the money automatically converts into the company's stock upon a subsequent financing of the company, and it makes that conversion at what is usually a significant discount from the stock offering price in that subsequent financing. So translating it to English, what do we mean? I give a SAFE note for $1,000 to company A. The terms of the SAFE note say that if company A raises $100,000 in preferred stock in a venture round, I get to convert the $1,000 into shares of preferred stock at 80% of the price, or maybe higher, rather lower, I'm sorry, at 80% of the price that the investors in that preferred round of financing paid. That difference between the full price of the stock in an offering and what the SAFE holder gets to purchase it at, or what the holder of a convertible note gets to purchase it at, is generally referred to as a clip. Okay. The third is convertible preferred stock, and we're going to talk about that in a minute. Of these types of issues, the best for the company is the straight grant of equity, because the convertible note constitutes a liability on the company's books. It also, you are obligated to repay the note if the investor elects not to convert it. And please, if there's one thing that you take away from this presentation today, please remember that point. Many early stage companies have come to misunderstand the nature of convertible notes and are under the impression that they are always converted and they'll never have to pay the money back. That's just wrong. It's wrong technically, and it's wrong in practice. So when you certainly hope that the investor is going to convert its convertible notes into the stock of the company, but when you are negotiating the deal, you need to evaluate it from the point of view of what impact will it have on the company if we have to actually convert that note. Preferred stock. Most venture capital transactions involve the issuance to the venture capitalist of what is called preferred stock. And as its name indicates, preferred stock has certain preferential attributes, over the common stock. Those preferential attributes include typically, and I'm not going to go into great detail here, but typically they include guaranteed dividends and liquidation preferences, what are called redemption rights, sometimes conversion triggers, and what we call management voting rights. So what do those mean? What that means is that an investor who holds preferred stock and who acquires that preferred stock pursuant to what is called a preferred stock purchase agreement, and typically an investor rights agreement, will negotiate terms that require the company to pay the investor a dividend each quarter or at the end of the fiscal year. Common stock in most companies do not require guaranteed dividends. The board of the company may declare dividends, and you hope they do, but it's not an attribute of owning stock. You can't demand the payment of a dividend as a common stockholder. Preferred stock has these often types of guaranteed dividends. They also have what are called liquidation preferences, and I'm going to spend a minute on this, and what I'm going to tell you is going to be a bit complicated, so stick with me. Fundamentally, the holders of preferred stock get their money first. So if the company makes sufficient profits to make distributions or dividends, the preferred shareholders will get their a designated percentage of that before anyone else gets it. That's called a preference. And even if they hold only 25% of the company through their preferred stock, they may get up to 80% of the distribution until such point as their original investment in the company is satisfied. So if I have invested $1,000 in preferred stock in the company, and the company makes $1,000 of distributions of its retained earnings, I get that first entire $1,000 or a minimum of 800 of that $1,000 because I have a preference, a preferential distribution right. Now, why is this important? It's important because that preferential distribution right floats through pretty much any type of money that the company makes. So again, sticking to a simple example, if the company is sold, usually preferred stock agreements will give the holders of preferred stock a preference, sometimes equal to 200% of the amount of money that they've invested in the company. This is how VCs get their returns in order to distribute those returns to the folks who have invested in their limited partnership. So if the company sells for $1,000 and the investor has placed $500 in the company, and they have what is called a 2x preferential return, the common shareholders don't get anything because the holder of the preferred stock gets the entire $1,000. If the company had sold for $10,000, the preferred investor would get the $1,000, and then the remaining $9,000 would be distributed pro rata between the common shareholders and the investor, preferred shareholder who just received the $1,000. So they get a double dip. They get their preferential distribution and they get their proportionate share of the remainder that is distributed to the common stock. Well, how does that work? Well, preferred stock is convertible into common stock. So if I hold 25% share if I hold a certain amount of preferred stock, again, sticking with simple examples, 1,000 shares, and there are 2,000 shares of common stock outstanding, when the trigger event occurs, in this case, the trigger event is the sale of the company, my 1,000 shares of preferred stock converts to common stock, in which case I have 1/3 of the company, okay? So what happens is I first get my preferential distribution, of $1,000, and then with the remaining $9,000, I get 1/3 of that, and the common shareholders get 2/3. You can see that the impact of a couple of rounds of venture capital investment can very significantly affect the return that a founding shareholder thinks they're going to get from the sale of a company. It can diminish it substantially. And it's very important that you take the time with experienced attorneys to understand how this works before you get a venture capital investment. I have seen so many clients who were not well advised at the financing round just be stunned when they recognized how little money they were going to get from the sale of the company. Again, moving along as quickly as you can, one of the other most important rights that a preferred shareholder has is what are called management rights or voting rights. If a preferred, notwithstanding that a preferred shareholder might only have 25% of the stock of the company, most venture capital investments give the holders of the preferred stock the right to make management decisions, meaning that no matter that 75% of the shareholders might agree that the company should buy a new machine or sell an asset or invest in a product, they can't make those types of major decisions without the concurrence of the preferred shareholder. So fundamentally, the preferred shareholder, even though they don't have a majority share of the company, are in a position to basically control what happens at the company. This type of provision is highly negotiated in these deals, and again, you need to be aware of it when you consider taking preferred stock. We discussed briefly the SAFE agreement. I'm gonna skip over that for now. If people have questions, please let me know, because I want to talk to you a bit about term sheets and the M&A process before we get too far along here, because I'm getting a little short on time. Term sheets. You'll have term sheets summarize the fundamental terms of either a financing transaction or an acquisition. Basically, they are usually 1, 2, 3-page documents that address issues such as the purchase price, the percentage of stock, the amount of the convertible loan, the due diligence period, the restrictions on the ability of the company to check to consult other potential buyers, and similar issues. In a merger, the term sheet will address the number of shares in the surviving company that the merging company is going to receive. It's going to talk about the value of those shares. It's going to talk about purchase price. It's going to have what are called earn-out measurements. That is, how are the shareholders or the former owners of the company going to be compensated, which is usually based upon the earnings of the company's products after the merger, and a lot of complicated subjects of that type. And I'll be pleased to talk about that in more detail. But the important thing to know is to never execute a term sheet without consulting an attorney. Term sheets, particularly term sheets that are prepared by large companies that are experienced in negotiating acquisition transactions, are works of art. And the terms that are used in the term sheet, although they may appear direct and appear to be presented in plain English, have a very significant meaning for the actual merger agreement or acquisition agreement itself. In terms of the process, a term sheet is followed by the negotiation and drafting of a far more complicated sets of documents called the asset purchase agreement or stock purchase agreement or merger agreement, or in the case of financing, the stock purchase agreement, preferred stock purchase agreement, those types of things. So all of those terms that are very succinctly described in the term sheet get translated into, or most of them get translated into, these more complicated legal documents. The problem is that many startup companies or inexperienced entrepreneurs think that because the term sheet is technically only binding, usually with respect to a couple of issues, which I'll address in a minute, that those terms can be changed as the deal goes along. I'm here to tell you that they can't in most cases, unless your company has a patent that is just a very strong knockout patent in an area in which there is very strong market demand and will provide the acquiring company with that type of demand and a lot of revenue, you are not going to be changing a lot of the major terms of the agreement. Now that, and if you execute the agreement by yourself, if you don't prepare with an attorney or another advisor before the term sheet is drafted or before you participate in negotiations, you're going to end up signing a document that you're going to regret. And I'll give you an example of that in a minute. So the purpose of the term sheet is to identify at a high level the fundamental terms of the deal. The term sheets are typically not binding with regard to those, binding meaning contractually enforceable in a court of law, that they're not binding except with respect to two areas. The two areas typically are the confidentiality of the information that's presented by each side to the other during the course of the negotiations, and secondly, a non-solicitation agreement, meaning that the acquired company or the company in which an investor is contemplating a financing will not seek financing from another source or will not seek another company to sell themselves to during the term of the term sheet. The terms of a term sheet are usually 3 to 6 months, depending upon the complexity of the transaction. They can be much shorter. They can be 2 weeks. I've typically not seen them any longer than 6 months. When you enter into the term sheet, you will then instigate the process that's called due diligence. Okay, the due diligence process will then involve the acquirer or the investor looking through the details of a company's business, their financials, their customer lists, their employee records, their loans, their debt, their inventory, their monthly revenue cycles and things of that nature. And you will need to be prepared to produce that information relatively quickly. Now, if you have a technology company and you've got some very proprietary software that has been developed in-house and is really the key to the company, what you're going to want to do is to consult with your counsel on how to disclose that software in phases, to as it were, open the kimono a bit at a time, because at least half of the merger transactions and probably close to half of financing transactions don't close for one reason or the other. And although that's less of a risk with a venture capitalist, it can be a real risk with a potential acquirer who will then take the information that you've disclosed to them and use it to your disadvantage. So let me give you an example. I'm still currently involved in a merger between one health information systems company and a larger health information systems company. Let's call them A and B. A is my client, and A is a smaller company with 75 employees and a niche application in an area that I won't describe it in any detail, but it has to do with physician practice management. The large company, company B, is involved in a variety of areas. The client signed the term sheet. The client had been a client of our firm on a number of other matters, but for whatever reason chose to sign the term sheet by himself. The term sheet was horrible. It was horrible in just about every important respect. It contained onerous non-compete provisions. It contained earn-out provisions that were unclear and basically left it up to the surviving company's discretion as to whether to even sell the products on which the earn-out was going to be based, meaning that if they acquired another product and discontinued Company A's product, Company A would have no revenue base on which to attain the bonuses and additional stock. The stock of the company that was being of Company B that was being exchanged for Company A's stock was improperly valued, and so it was impossible to determine whether Company A was getting the consideration that it deserved. The Company B agreed to pay off certain debt of Company A, but the terms under which that debt would be repaid were so complicated and were tied to the merger agreement that it made the guarantee to repay that debt basically meaningless, and on and on. And there were a number of things like that. All of these situations would have been avoided had the client come and talked with me or another experienced lawyer prior to signing the term sheet. And having said that, the client was under the impression that the term sheet was very clear. And he was under that impression because he didn't recognize that the terminology used in the term sheet had very significant legal meaning in the context of the subsequent merger agreement. So what I am just strongly suggesting to you is do not sign something in a restaurant or in a burst of exuberance. Always go check with somebody else, okay, who has more experience in this. Again, I want to say another minute on consultants and personnel folks and why it's important for you. It's so important for you to make certain you have in place necessary agreements. And again, I'll use an example. I did several years ago here in Orlando, I represented a client that was about to get some financing from a significant venture capitalist. And it turned out that the critical elements of the software in which the investor was investing in, which was the principal asset of the company, had been developed by one of the founders of the company before he became a founder and was acting as a consultant. The company never obtained a written agreement from that developer, and he never assigned the rights to that software to the company when it was formed. So fundamentally, the company didn't own the software on which the investor was contemplating its investment, and When that fact became known about 3 days before the transaction aborted, and nobody was happy. Probably least of all the company, because they had incurred some pretty substantial legal fees at that time, but had nothing to show for it. It is critical that when you retain a consultant that you have a written agreement, and it's critical that that agreement contain the necessary assignment of rights. And it's critical when, particularly in the technology business, when you use a third party to develop a product or to modify a product or to enhance your website, whatever, that you have a solid agreement. They're not expensive for an experienced attorney to prepare, and don't, in that respect, don't get them from LegalZoom or some organization like that. There are some things that LegalZoom does well, but almost anything that isn't a rote document is not an area where you want to try to save money. So I've covered a lot of ground, and I've probably talked more than any of you want to hear me talk. So if, to the extent that you have any questions, I'll be pleased to respond to them. And if not, thank you for your time.
Does anyone have any questions?
I put them all to sleep. This is complicated stuff. I don't see any. So
yeah, I don't see any on my end either. Well, okay. Well, if there's no questions. If there's no questions, I guess we can close it out. Thank you, Terry, for your presentation. Really appreciate it. It was great stuff, great information that you presented today. For those who are still here, please watch out for a seminar survey that we're going to email out in the next couple of hours or so. We greatly appreciate your feedback. This helps us to kind of plan and up our future webinars and seminars in the upcoming future. Please let us know if there's something we can present on, if we can, or anything we can improve on. Thank you again. Thank you all for attending. Thank you again, Terry.
And if anybody decides that they do have a question, or you have my contact information, please feel free to send me a note and I'll respond to you, and I won't charge you for it.
There you go. No charge. So you feel free to download the presentation that's in the handout section of the GoToWebinar platform. It has all Terry's information. If you don't have it, you can email me. And also the slide deck, the current slide right now shows Terry's contact information as well. Okay. Again, thank you all for attending.
Okay. Thank you.
Please be on the lookout for the webinar survey, and we look forward to hearing from you soon.